presenting, and honest, neutral, and a presentation made without prejudice or bias against anybody. I'm also in a very good position because I benefit from the fact that I have lived through a difficult period as a child in this country. My own father used to be dragged out of his bedroom, and I always thought it was one of the normal things of our time. I didn't have the ability to think that what was causing that is the absence of constitutionalism in the country at that time, and that anarchy prevailed. I also, apart from the fact that I managed to benefit from good programs of this government to go through varsity after independence and have a reasonable life, challenges in this society, such as land, although I have a house, a small farm in Katavi, not a resettlement farm, my house at Tonyani. At 5 this evening, when people close their offices, 6 of my siblings are going to other people's houses to listen. Notwithstanding my efforts to pick them up, it has been a very difficult situation. So I'm not speaking here as if I divorced from what is going on. But let me start with my presentation. Now, in my presentation, those who will get an opportunity to read, I decided upfront to recognize the untold suffering and injustice suffered by Namibia, all the indigenous groups. But the massive injustice, particularly in relation to land dispossession suffered by Herreros, because it was also accompanied by genocide, Nama and Tanara, were too bad, were so degrading to the extent that we can never forget. The cry and calls for reform by dissidents, all of us, are understandable. Are understandable because people suffered, and that is the reason that in the early 60s, the founding fathers, Dr. Hage, Dr. Pohamba, Dr. Chabibi, Dr. Kurira, the Nahas, Jerry Kanjo, later on, everybody. People drawn from different tribes of this country as united force decided to take a common stand to go and fight. After fighting at independence, then we decided what is our constitutional vision for this country, looking at the background. And the vision that our founding fathers that set to craft a constitution for us is apparent from our constitutional preamble. Because you can see from the preamble that the injustice, the fact that there was no constitutional oversight, people would disappear, people would be hanged, kids will be left without fathers and mothers. Our founding fathers wanted to break, notwithstanding untold injustice. They decided we must, for ourselves, set a dispensation which, if we were to leave this country through there, our kids and our grandchildren, we will have left with them a very good constitutional democracy, so that what we were subjected to when bad leaders comes amongst us, who may come to call for death penalty to return, there is a constitutional order that bind us together and will be used as a bar for us not to return to the brutal and shameful past. So now, with that constitutional and historical background, let me then start with the presentation that I think will assist you. Because in certain respect, the constitutional provisions that we'll be speaking about shortly will be presented you with an opportunity to make very good reform. But unfortunately, and we should not fear about this, some of them will prove to be legal and constitutional impediment in whatever we want. We must also be careful, because those who advances views putting in doubt, putting in dispute our unitary statehood relies on articles such as that Article 23 that obligate Parliament to make law to pick up people that were in the past subjected to untold suffering. So they rely on one part of the Constitution, but yet they undermine another one. Those who do not want ancestral claims, they say Namibia is a unitary state, so they rely on unitary state, but then they also take away other people's right. For me, what I want to do is to make a presentation so that we honestly, if there are things we cannot do as far as the Constitution is concerned, those things cannot be done because that is what we set ourselves. If there are things we can do in terms of the Constitution or in terms of legislation, then we can do. Now, one thing we don't remember is this. The Parliament, National Assembly in particular, those who have your Constitution, people say when you want to change Article Chapter 3, we probably just have to change it. But that is a small problem. There are bigger problems because you will find that, in fact, the National Assembly is under obligations under Article 63, sub-article 2, that the National Assembly shall further have the power and function subject to this Constitution. Already at that starting point, the founding father, when they said, when they discussed through consensus decision, whatever law you, even before you start standing up in the National Assembly, there is a constitutional bar not to make obligation to make law subject to the Constitution. First one. Simple as that. Yet, our Supreme Court, in a very difficult case, just like then, that also was very emotive. Labor hire, our Constitution, our Supreme Court, despite the public pressure, in a judgment in 2009, stated, and I quote shortly, the purpose of the freedom in Article. Can I then start with the topical issue of amending the Constitution? Yeah. In particular, Article Chapter 3. First of all, it's not correct that Chapter 3 cannot be amended. It can be amended, but only if you strengthen and enhance the right. So first of all, the provisions is not, it's not correct, misleading to say chapter 3 can never be amended. What is prohibited, what is prescribed is to amend with the purpose of diminishing the rights, including liberty, including life. Now, people speak about Article 131. 131. There must have been something that our founding fathers thought. They wanted to cement something. And they choose different areas of rights, ranging from right to speak, ranging from to right to liberty. But all these rights, by the way, are subjected to some limitations. They are not open-ended. But Article 131, and here I'm speaking with no degree of doubt. Simply, the purpose of that article is to entrench. It's like a law. Because it's telling you that no repeal or amendment of any provisions of chapter 3 hereof, insofar as such repeal or amendment, repeal means to abolish, amendment means only to, yeah. So both a repeal or an amendment are prohibited if such seek to diminish rights in them. Now, then you go to Article 132. It's about amendment or repeal of the Constitution. So in other words, our Constitution could be repealed or could be amended. And it speaks about how you amend the Constitution. 2/3 in the National Assembly, 2/3 in the National Council, and it tells you, if the National Assembly get 2/3, the National Council does not get 2/3, the President by proclamation, if he deemed necessary, can order a referendum. But the referendum, by the way, can only be made if there is a law dealing with the referendum. Exactly, it's incorporated now in the new. Yes. So now, but Article 132(5) say nothing contained in this article, otherwise in Article 132, shall detract in any way from the entrenchment provided for in Article 131 hereof, the fundamental right and freedom contained and defined in chapter 3. In other words, under Article 132, you are again being reminded that the power we give you to repeal and amend the Constitution through national parliament or referendum, those powers do not include the power to detract from the entrenchment. Back to square one. So you can, one can debate and debate and debate, and one can cut pieces from the Constitution through amendment. Chapter 3, you can only add substantively on the right in place there. But let me make it easy. It's not that there are problems. If the problem is Article 16, Comrade President, and sub-article 1 and 2, I don't think there is such a huge problem. There will be challenges that we cannot navigate through this problem, through those provisions, by making proper legislation that assists our people. Because one remember, Comrade President, that Article 16, 1 in particular, it gives people, and this is important because it's a misunderstood respect, First of all, Article 16.1, it first gives people right in any part of Namibia to acquire, that is one. In other words, to get, to acquire, to own, after acquiring, to own, and dispose. In other words, to sell or donate of all forms of property, including immovable property. So, in other words, we have fundamental right to own immovable property among which is land, and movable property individual in association, and to be bequeathed. But there is a provision, provided that Parliament may, by legislation, prohibit. My word delegates fellow Namibian. By legislation, Parliament may prohibit or regulate as it deems expedient the right to acquire. Now, initially, it speaks about the right to acquire, own, and dispose. Now, it says Parliament may, through legislation, prohibit or regulate the right to acquire. It left out own and dispose. The right to acquire of a property by persons who are not Namibian. So in other words, the legislation then, the constitution then says, you have the right whether you are a Namibian or not a Namibian. However, Parliament can regulate how a foreign can acquire property in Namibia. That also includes that. Then to give you an example, then what happens when we come up with the Agricultural Commercial Reform Act, which deals with the resettlement? Then instead of regulating only the right of some, it also regulated the right of Namibian, and in particular also formerly disadvantaged as far as selling is concerned. In other words, it says if you are selling your farm, even if you are a black selling to another black, both of you are formerly disadvantaged. You must first offer to the state. Even if there is a former disadvantage, who does not have the farm, who does not have the land, you are obligated, when you dispose, to first offer to the state. Instead, ahead of regulating foreigners when they acquire or when they dispose, or even those who only were advantaged during your time. Then the next article is Article 16.2 about expropriation. But let's be frank about this. I think we have, although it's not the excellent piece of legislation we have, but we have the Ordinance Expropriation of 1973 is still on our statute book. That is a general one on expropriation. Then you have the Land Reform Act, which in relation to expropriation of commercial funds. Now, obviously, the consideration the minister must look at when negotiating price and when deciding to expropriate are not that good. They must be looked at. Because, to give you an example, in South Africa, when they expropriate, the relevant competent minister responsible for that, as one of the considerations when you negotiate, when you pay compensation, you look at the price of acquisition, the history of acquisition. History of acquisition, so that if you have two formerly advantaged people that want to expropriate their farms, one is a white, good advocate who represented claim fighters, worked hard, made money, never supported apartheid, bought his farm from the open market. Then you have a Kufut guy who was rewarded for participating in Kasinga massacre. Then that should be a consideration in terms of price. Because you are then given power to look at the history of acquisition. when you grapple with the question of what is just to the owner of the property and the society. So, but you can make reform in the context of legislation, tighten them up, bring in more, which is good for your people. Let's talk about in 2007, government did well, tried to expropriate the absentee landlord farm. I think it was 3 farms. We are trying to take huge decisions and possibly at a larger scale, and we will fall into problems if we are not careful. Because if we don't also address other associated problems such as human capacity, resources, and skills, even if you have good law, because I have the judgment of those cases, I have the judgment. In fact, compensation, just compensation was never dealt with by the High Court. The cases only failed at the question of whether or not government must expropriate those farms, because even notices, just notices to serve notices, we didn't get them correct. Just to serve notices. After the High Court even put up a catalog of ways how to do it, the government obviously. So sometimes we want to make pronouncement that may really prove difficult for us to manage, but sometimes it's because we don't look at what we have and see whether we could do with such. And I believe that while it's not possibly the property article is not the best we would have wanted to have, some way we could have, we could manage. I'm moving on with speed. Now, let me then deal with the in South African example of indigenous claims. In my paper, I have recognized that hardship, not decided not to be dismissive or not to be too for anything. Just try to analyze the laws and see what we have. You find that in South Africa, under Section 25 of their constitution, they have a provision in their constitution, constitutionally ordained indigenous land claims. They are there in the constitution. And they say those who were dispossessed of their land through colonial discriminatory policies, only from 1913, for good or for bad, they decided if you lost before that, you can claim. But the South African land claims, and I refer to only one example, Comrade President, found it difficult in one case, and these are major problems when they are implementing it. And it commented in the judgment, of a community that want to claim restitution. First of all, I must explain that when you talk about indigenous land claim, when you end the indigenous or ancestral land claim, when you start adding restitution, we are talking about a claim like if you are defamed, defamation. And there is always a question, what is the remedy? What do you want? You want to be paid compensation, what do you want? Restitution is restitution of lost land. So in other words, you are going to be put in a position you were before the dispossession. So we must be very careful. When you just use terms and say, indigenous land claim restitution, what do you want? Then one says is that geographically, whatever he had, I want restitution of that lost land. Now, South African, where the right is in the Constitution, the land claim court in one judgment then said, then there is the reality that restoration of land within the towns would require, as envisaged by the ninth respondent, townspeople to be expropriated of their houses. The expropriation of schools, churches, parks, and other facilities as could occur also in respect of numerous businesses, industries, and other economic activity and so forth. Now the court they found themselves in a situation where we put this right in the constitution and give people right when what the restitution. But because of the changing world, we introduce towns and so forth. And we say it's a unitary state, not like Nigeria, federal state, move freely. We invited everybody. Now what do we do with it? So, but one must look at other things. Can it be addressed through alternative equitable redress? For instance, in our law, not in a direct discriminatory way, because all people of Namibia have the right to stay wherever they want as contemplated state, because it is in the constitution. But I think one can, obviously, because we do it with marginalized people in some of our policies, to factor in, like a tender, 1 or 2%, if you have two individuals. This one is saying, my grandma lives in this area or so forth. The other one will have two applicants, there are two farms available. You see whether, I'm not saying, these are things to be debated and interrogated. Maybe you factor in some redress in your policies, but not to throw away the constitution. Never. Because this country is still, I think those who have suffered for many years, and some people still have scars, they can never live a day without a constitution in this country. Because then we start with revenge. Then we cannot speak to kids in the street when we say they are making pronouncements that are unconstitutional. We want to change them from school because they are advocating for things that will destroy our peace. But nobody has exclusive domain to encourage things that are not constitutional. We must all who are enriched, celebrated, the maligned, we all have the same right. So it is dangerous from a point of view of an independent legal practitioner who practices in the Supreme Court and in the High Court. I'm at the same level with a member of the executive, legislator, and judiciary, all of whom have taken an oath to respect the Namibian Constitution.
Absolutely. Yeah.
So, then, in conclusion, I have skipped a lot of articles because time is not on our side. Comrade Hage spoke about Article 100 of the Namibian Constitution. It says that independent natural resources, water and land, government of state has sovereign ownership unless if such land is otherwise lawfully owned. Obviously, now you have land all over, including communal areas now. When you fit in a question of, what is it, indigenous, yes, it becomes problem. It's a claim against the state, for instance, in rural area, what is a claim about? I'm not dismissing it, an idea. I'm discussing it so that we think and interrogate to assist us in our deliberation. What are we trying to say? There are huge problems. Of course, they need to be reformed because I checked our Section 3 of the Local Authorities Act. Give the minister responsible power to declare towns, even in communal areas. Yes. It does not speak of compensation. One can go and look at it. Does not. That's why we have problems all over. But then, in the Communal Land Reform Act, Section 1540, yes, communal land is established and recognized by the President in terms of Section 15, and Section 40 prohibits compensation by the way. There is even a heading says prohibition to compensation. But there is an exception, which says you can only be compensated if you reach an agreement, if you are transferring your communal right and you have built improvement or whatever. So very discriminatory, very bad. But then in the Local Authorities Act, there is nothing. Then the Communal Land Reform Act says if the president withdraw land from communal area, those who are there may be compensated for this legal compensation. But yet the local authorities is silent. So all these laws need to be looked at properly so that tangible reform for the benefit of our people are made. Because if we are not careful, people will think the problem is the constitution. Of course, the constitution may be a problem here and there. But in most cases, it is within our policies, within our laws that are not properly considered. And therefore, in conclusion, I'm moving fast because the Comrade President, I need to say this. In one of the cases in the Supreme Court, we were reminded, and this captures really why there is a lot, and we must understand everybody will try now, because people suffer, substantively suffer, and the effect are felt by everyone. The Supreme Court, but in trying to remind us what happened to us and how we arrived at independence, stated in the judgment and said, self-evident as this right may now seem to sovereign nation who by revolution or political evolution attained democratic self-governance long ago, it has been denied the people of Namibia by successive colonial and foreign regimes for more than a century in recent history. It was ultimately won only 2 decades ago, after a protracted struggle for liberation and independence. The cost of victory measured in human lives, endurance, endeavor cannot be calculated. Determine that the right which they have gained as individuals and as people should be preserved and protected for themselves. These are Namibian people being spoken. And their children. Namibian resolve that it will be done most effectively in a democratic society. Our constitution is against anarchy. In the preamble, it speaks about reconciliation, unity. When we say one nation, one Namibia, there is a substantive content in it. We choose how do we reject people that killed people in Katima in 1999. We rejected them. Not only within the law, not only through using the Namibian Defense Force that is constitutionally empowered to defend our territorial integrity, but we also rejected them by telling them that Namibia is a unitary state. So we can't, because next time somebody will want the constitution to be amended so that we remove the constitutional format of the state as a unitary state. A bad leader masquerading amongst us in 20 years from now, a bad one like Idi Amin, will want to say, because I have no control on the media, I have no control on this citizen, I want to remove freedom of speech. We can never go back. So with that presentation, just like the one of the group Hamba is also available for distribution. I hope I was not speaking as the higher class. I was not speaking as somebody who lives elsewhere. I was speaking as a child of Namibia. I was speaking as somebody who lived through all this and somebody who is very proud of what we have chosen as a country and somebody who have benefited from the legacy. And I know my kids will live better than I did when I was a child if we play within the constitutional confines. Honorable President, that is the least I needed to say.